Welcome back to the video lecture on East Asia's cultural influence law of the sea. This time we continue to talking about the recent trend of the attitude of the Asian state towards third-party adjudication. In particular, we touch upon the issues of the China and focusing on the South China Sea arbitration. On 12 July 2016, the Arbitration Tribunal constituted under Annex VII of the UNCLOS issued its final award in the dispute between the Philippines and China over maritime claims in the South China Sea. The Arbitration Tribunal, in a 500-page final award, unanimously decided in favor of the Philippines and applied the rules of international law principally by UNCLOS, the universally regarded as a constitution of the oceans and the other rules of international law that are not incompatible with the convention. There have been extensive body of the scholarly work that explore the various facets of the arbitral award, especially the commentaries that focus on its legal aspect. The Arbitration Tribunal categorically declared that Chinese non-line claim and Chinese historical rights over living and non-living resources in the South China Sea are incompatible with UNCLOS. The tribunal clarified that the China does not possess historic rights over the resources within the non-line area when the Philippines is or the contention shelf, and that any historic rights that China may have over these resources are incompatible with UNCLOS and have been extinguished by Chinese accession to UNCLOS and its entry into force. The tribunal further clarified that any claim by China to historic rights to the living and non-living resources within the nine-dish line beyond the limit of Chinese maritime zones are provided for under UNCLOS has been superseded by the entry into force of the convention. In the tribunal's view, the Chinese ratification of UNCLOS did not extinguish its historic rights in the waters of South China Sea, but rather constitutes a relinquishment of the high seas freedom it previously utilized, which have been subsumed under the regime of the EEZ as defined by the convention, for which it gained a greater degree of control. The adoption of UNCLOS in 1982 has led to a period of relative stability in global ocean affairs by providing a legal framework for the sustainable development of the oceans and its natural resources. However, recent discussions highlight call for amending the convention due to the perceived shortcomings. Against this backdrop, the questions arise concerning efficacy of the UNCLOS in preventing and managing conflicts related to marine resources. The particularly relevant is the role in addressing the South China Sea disputes. For example, is UNCLOS playing a positive role in addressing the South China Sea disputes? To what extent do the state involved in the South China Sea recognize the connection and relevance of UNCLOS and settlement of dispute in this region? Many South China Sea scholars, particularly Chinese, exhibit skepticism concerning the role and efficacy of UNCLOS. Their argument revolves around UNCLOS provisions exacerbating the complexity of South China Sea dispute, such as the contention between historic title concept and exclusive economic zone regime, as well as fierce competition for territorial claims in the region. UNCLOS may be perceived to have a certain shortcoming, such as lacking a definition of a historic water regime, but vague provision on the status of the island rock, a lack of clear provision on the legitimacy of military activities in foreign countries, the EEZ, and the limitation and exclusion of the third-party compulsory dispute settlement, hindering timely resolution of many disputes. Notwithstanding these challenges, the prospect of the third-party forum assuming a constructive role in resolving these issues endures. First of all, the Article 1213 of the UNCLOS does give the courts and tribunal a role to play in this picture. Neither Article 297 nor 298 exclude dispute related to the definition and determination of the feature to be an island or rock from the compulsory dispute settlement mechanism. The Philippines, in its notification and statements, has rightly pointed to this. The second, by closely reading the provision of the UNCLOS, it is fair to claim that the court or tribunal has a role to play in many issues, such as prompt release and environmental protection. The third-party forum and third-party adjudication upon request can determine the nature of the specific military activities and thereby provide the guidance on whether these activities are legitimate in a foreign country's EEG, which would to a large extent reduce the potentially the military conflict in this regard. All the states involved in the South China Sea dispute have developed a comparatively comprehensive marine legal system upon the framework of the UNCLOS. These legislation provide the legal framework to deal with many maritime issues in domestic context. Nevertheless, in the situation where multiple issues interrelate with each other, such as the South China Sea, a theoretically robust legal system may not constantly yield favorable outcome in crucial areas, such as the maritime delimitation, overlapping maritime jurisdictional claims, and fishing disputes, transboundary marine environmental protection, among others. Consequently, a third-party compulsory dispute settlement regime is imperative to fulfill its intended role in resolving these intricate matters effectively. China consistently opposed intense litigation, the favoring negotiation as the preferred approach in all instances, whereas the Philippines is more inclined to involve third-party intervention. Nevertheless, in recent times, compelling arguments have emerged advocating for China to embrace the third-party dispute settlement mechanism more readily. This shift is encouraged due to China's expressed aspiration to assume greater responsibility in addressing contemporary global challenges and its active role within international organizations. When you're talking about recent trend of the attitude of Asian states towards third-party adjudication in terms of China, it is very interesting. This South China arbitration has serious implication to one of the issues Korea has in terms of island issues about Dokdo. As I mentioned, on 12 July 2016, the arbitral tribunal formed under Annex VII of the 1982 United Nations Convention on Law of the Sea, UNCLOS, issued its award on the proceeding brought by the Philippines against China relating to certain activities in the South China Sea. The award deals with various important issues relating to law of the sea and the interpretation of the UNCLOS, such as the jurisdiction of the tribunal, legal status, maritime features, historic rights, and duty to preserve the marine environment. The impact of this award is felt worldwide, as it would undoubtedly influence other unresolved issues in other parts of the world involving island and maritime features. This is a case particularly in East Asia, where the South Korea occupation of the Dokdo is challenged by Japan. Like China and Philippines, both Korea and Japan are parties to UNCLOS. Like China, South Korea on 18 April 2006 also made a declaration under paragraph 1 of the Article 298 to exclude the issue of maritime boundary delimitation and military activities in the exclusive economic zone from the compulsory dispute settlement mechanism under Section 2 of Part 15 of UNCLOS. Despite the fact that UNCLOS does not deal with any dispute regarding territorial sovereignty, and despite Chinese declaration to exclude maritime delimitation from the compulsory dispute settlement mechanism of the UNCLOS, the Philippines managed to bring China in front of an arbitrary tribunal and successfully obtain a ruling that some of the Chinese occupation and activities in the South China Sea are unlawful. Thus, can one party unilaterally bring a case under Part 15 of the UNCLOS on the issues of the occupation and activities in Dokdo? This lecture will discuss and address the relevance of the word on arbitration case between the Philippines and China and its relevance to the issues between Korea and Japan regarding Dokdo. In the position paper, in terms of South China Sea, the China argued that the case involved sovereignty dispute over land territories, which is not covered by UNCLOS. Even if the tribunal decided to distinguish the sovereignty disputes from the maritime dispute, China argued that the maritime dispute is so intertwined with the issues of the maritime delimitation that it is impossible to settle one without affecting the other. Since China has made a declaration to exclude any dispute concerning maritime delimitation from the jurisdiction of the UNCLOS dispute settlement regime, China asserted that the tribunal was formed without any legitimacy and has thus refused to participate in any stage of the arbitral process. The Philippines argued that such disputes are not excluded by Chinese declaration because they would not require the tribunal to delimit the maritime boundary in an area or determine which state has sovereignty over the island and other geographic features in the area. Although China has made it clear that the position paper should not be regarded as Chinese acceptance of all its participation in the arbitration, it remains the only official statement of Chinese position regarding its objection to the jurisdiction of the tribunal. The tribunal, having had no response or argument whatsoever to consider from China, seized upon the position paper and decided to treat it as constituting a plea concerning the tribunal's jurisdiction. The issues regarding Dokdo between Korea and Japan are mainly related to Korea's sovereignty over Dokdo, which is challenged by Japan, as well as the effect of Dokdo on maritime delimitation between two states. If international judicial dispute settlement is sought on both issues at the same time, the case could take a long time to be completed. Nevertheless, the determination of the sovereignty over Dokdo without the large-scale, the second phase of the delimitation of maritime boundary is unlikely to resolve the issue between Korea and Japan. It is unlikely, however, that the issues of sovereignty over Dokdo and maritime delimitation between Korea and Japan will be brought in front of an international judicial dispute settlement body without the consent of both parties. Dispute settlement mechanism under UNCLOS also would not be able to hear the disputes, not only because the issues of the sovereignty is outside of the scope of the convention, but also because Korea and Japan have both expressly excluded maritime delimitation from the application of dispute settlement mechanism under UNCLOS. Following this, since no international court or tribunal could resolve the sovereignty issues of Dokdo, any issues regarding fixed activities within 12 nautical miles of the Dokdo also would not be able to be resolved, as this would depend on the determination of which state has sovereignty over Dokdo. However, Arbitral award in a case between Philippines and China raised a concern about broad jurisdiction being assumed by arbitral tribunals, as well as by the International Tribunal for the Law of the Sea, something that might lead Korea to engagement in a judicial case by accident. For example, action on part of the Korea in the waters around the Dokdo, for instance, the construction of the ocean research station proximate to Dokdo, as has been completed in recent years, could conceivably leave Korea open to involvement in a case brought by Japan under dispute resolution mechanisms provided for under UNCLOS. This is because such activities on a part of Korea could be construed as matters directly relating to the interpretation of aspects of the UNCLOS, especially the obligation to protect and preserve the marine environment under Article 192 in the duty to cooperate under Article 206. These questions would therefore not be covered by the exclusions set out in Article 298 of UNCLOS, which Korea invoked in its declaration of the 18th April 2006. While any such challenges could not address the question of the sovereignty of Dokdo, such a development may be unwelcome from a Korean perspective, for instance, potentially leading to a judicial pronouncement not only concerning the lawfulness of activities undertaken by Korea and whether such actions constitute an aggravation of disputes, but also concerning the state of Dokdo as an island or rock. Thank you very much for your kind attention.